You're aware, no sooner the government was installed and we were confronted with the urban local bodies elections in our state. This is not new to all of us. You are well aware of the past and what transpired in all the government's attempt to hold these ULB elections over the years. I wish to clear the air on matters relevant to the court and the state government's position, which was grossly misunderstood by our people on this particular issue. I would like to take you back a few years earlier, how this came about. In the year 2001, the Nagaland Municipal Act was enacted by the State Assembly for the first time. In the backdrop of we being a resource crunch state with almost zero revenue, our government had to look out for fundings to develop our state and our towns and cities. And the central government gives funds as aid to our municipalities and the town councils only if we enact a law to constitute the municipal councils. So perhaps in their desperation, the government of yesteryears had to enact this 2001 Municipal Act. While doing so, we don't allege them of any ill motive. I am certain that it was with good intentions to develop our state and benefit the citizens that they quickly adopted this resolution and brought about this act. Little knowing the consequences of endorsing Article 243 and the Series A to Z, and with it, the 74th Amendment of the Constitution of India. So, this traces back again to the 73rd Amendment, which was in place prior to 1992. And the transition of the 73rd being superseded by the 74th Amendment, there were a lot of other articles in the Constitution which came along with it. Perhaps, without wanting to point fingers or finding faults of the government of those years, I have to point out certain oversights on the part of the executive, the bureaucracy in our state. It is their part to properly advise the government of the day. So what happened in 1992-93 was all the secretaries of different states of the urban development departments were asked to put in their opinion, forward their suggestions, if any any rectification is made, to be made, that was the appropriate time. So several secretary-level meetings were held, and a lot of correspondence also took place between the states and the center of the Urban Development Department, whether the new act was appropriate, whether it suited them, whether it will go down well with the states, because India is a vast country and different regions, different states have its own peculiarities. So for an entire year, from 93 to 94, time was given to all the states to react. Unfortunately, if we recall back, we had the municipal departments only a few years back, 2-3 years back. And even the Urban Development Department was only a small cell under the Planning Department, if I remember correctly. So we had no full-fledged Urban Development Secretary at that time. So I doubt whether there was any correspondence with the Ministry of Urban Development from our state, or whether any secretary represented our state at any level for discussion on this matter. So we missed the bus, and we could never respond to it, and the Act, the 74th Amendment, was adopted by our State Assembly in 2001, just as it was. So along with these central acts, there are so many laws, regulations which come along. So after 2001, our state government had tried to amend certain parts of that Nagaland Municipal Act from time to time, at least 4 or 5 times. But it failed to fulfill the desire of our people. And so we have had a lot of hurdles over the years in our attempts to constitute the municipalities. So we have reached this stage. After 22 years, we have reached a stage where we had to take a relook at the entire act, and that is when the State Assembly has resolved to completely repeal this 2001 Act and go for a new act of our own, the laws and regulations of which will be framed by our own people to suit our condition and situation. So now, why the state legislature has opted to repeal this act in toto? The 33% women's reservation came to the fore, and some certain sections of the society dragged the government to the court. So here there was a tussle in between our own people, where the social practices of our Naga society, be it any tribe, does not accept the imposition of a fixed percentage being imposed on the representatives for women folks. Because it is not akin to our culture and our social practices. we had an extreme custom, maybe, and a traditional practice where women were barred to partake in many areas of our social life. But over the years, we have made a lot of concessions, and to keep pace with time, we have removed all those restrictions, and you have seen women taking part in the former male-dominated areas in our society also, including leadership. I did not say, and you know it well, that in the early 70s also, much before any of the northeastern states had women representatives, we had our late Auntie Rano Shaiza, who was elected to the Lok Sabha, the lone seat from Nagaland. She was a woman. There was no reservation. And even today, without any reservation, there are 2 women representatives already in the State Assembly. Out of the 3 of them, 2 returned with the mandate of our electorates without reservation. And in so many areas where it was a male domain, in sports too, we have seen women folks becoming wrestlers, where even to cross the procession of the wrestlers entering the ground were restricted by a woman. And you see the women folks in our police forces these days carrying automatic rifles and guarding our state, which were actually not practiced in the past by our people. So, you see, we have restrictions. We have social practices where women does not hunt, whether it is for trophy, whether it is for game, whether it is for food. We don't let them carry the spears, the darts, and the guns. And it is also a social practice that no man folk weaves a mekhala or a shawl. It is not forbidden, neither it is an offense. It is simply just not practiced in any Naga village, anywhere in the Naga inhabited areas. But of late, we have removed all these hurdles, and it is already an accepted norm that we have women representatives even at the lowest grassroots level local bodies like the village councils, where we have women representatives, the village development boards, where we have women VDB members also, and so on and so forth. Everywhere it is all right. So we feel that women have found a place in our society today, and whatever is necessary pertaining to our social practices, we will accommodate, but people, the government, must be allowed, must be permitted to frame our own rules, our own laws, in as far as our social practices are concerned. This is derived from the Constitution of India, wherein the Article 371A has clearly stated that no act of parliament in respect of our social and religious practices, our customary laws, and our traditions will not be imposed by any central law unless the State Assembly accepts it by a resolution adopted by our state legislature. So today, after having tried the 2001 Municipal Act, we have run into a lot of controversies. So thereby, the state government has taken a relook, and we have completely repealed the old act on the 28th of March, and the government, the legislature, will be constituting a panel, a committee whereby this committee will have a wide-ranging consultation with all concerned and will bring about a new act which is befitting to our way of life, our social practices, and the state legislature will adopt that new act for our Nagaland Municipal Act as early as possible. So that is where we are. This made headlines. It was on the 17th of this month, the latest order of the Supreme Court of India. You can see there on the first page, 17th of April. In the last para, you can see the order. In the second page is the full order here. Our media houses carried in your front pages that a contempt of court has been notified, and our Chief Minister, Mr. Rio, has been pulled up by the court. Our state government has been pulled up by the court for contempt. Now, I would like you to read through this carefully. It's only a one-page order. Nowhere is it mentioned a contempt of court has been ordered. Nowhere. So I don't really understand how certain quarters among us have resorted to that statement that the court has pulled up the chief minister, the court has pulled up the state government for contempt of court. It is unfounded. This is baseless. That is why I'm giving you a copy of this order. It is the Supreme Court's own original order, and it says here, in the first para, they deal with a reference to the previous court hearings, whereby they felt betrayed, maybe, on certain understanding between the legal team and the court. But the crux of the issue is in the following paragraphs, where they have referred the matter to the Additional Solicitor General of India, who was there representing the Union of India on behalf of the government of India. And what he says, what he stated, his submission was that the government of India was only asked to send additional supporting paramilitary forces to the state to conduct the panchayat, which they mean the urban local bodies elections, to assist the state, and nothing more. But the main portion of their order deals with the opinion of the government of India. Now that the State Assembly, the legislature has repealed the Act of 2001, what is the stand of the government of India on this? Whether it is acceptable, whether any action should be taken upon it, or everything is all right as it was. That is what they are asking the Additional Solicitor General of India to reply back to the court within 2 weeks, effective on the 1st of May, the next hearing. So here they have asked him to make special reference to the Article 371A. What does it deal with? What are the provisions therein, which have, from where the State Assembly have derived its powers to repeal a central act. That is what they have asked. Because perhaps the matter is sub judice, and I will not go into detail, but only basing on the orders here. My interpretation and our layman's understanding to this order is that the court has not been appraised of the provisions of those articles and subclauses which refers to our customary laws, our religious and social practices, and other things. So they have asked for more documents, more information on these articles, and they have asked our legal team, in the last you will see, to make these presentations on the 1st of May. That is to say, what special constitutional guarantees have been given to us under this 371. And I don't blame the judges or the court, because even politicians from the mainland don't understand our social practices too well. They are not conversant with our way of life. So, judges, lawyers, it is least expected of them to understand our culture, our custom, our practices, when their life is confined to the court most of the time. So rightly, they have asked the team, our legal team, and the additional Solicitor General to make a presentation on our background of the customary social religious practices. That is all. And that should be made within a span of 2 weeks. So I believe our Advocate General and his team, our legal team, are preparing all necessary documentations to make a presentation to the court on the 1st of May, which should clear the air and throw some light on the background. And we expect the court to give a just judgment to our case here. So there is a gross misconception on the part of all concerned that there was a contempt of court. So this is badly miscarried. This is where I would like to make a request to our media houses to kindly authenticate any matter from the source where it originated before it is written or publicized for public consumption in future.
So you see in the fourth line itself, it says, that what is sought to be done is in breach of the undertaking given to the court. It is already mentioned there, it is a breach of the court's order, because the court had already sought that the election should be held by 16th of May. But now that we are asking to repeal, we will not hold the elections, but we are going for repealing. So it is saying that it is breach of the undertaking given to this court. So doesn't it mean contempt of the court?
No. If so, they would have added a line bottom in the bottom that this is a breach, and so it is amounts to contempt of court. But it is absent. I would not say that. They have just made a statement on their observation of the proceedings, maybe. So what was the order? This is the 5th. On the 5th, preceding the 17th, I have the order here. And here too they have asked, it is very light, I must say, for a Supreme Court order. It's very light. They have asked us to conduct the municipal elections. But that is to the State Election Commission and the government. So when the state legislature, the government was fully prepared, they have issued all the notice also for conduct of the election. They were fully prepared, but when the situation did not favor, they have been trying to postpone it further, seeking more time the court intervened again, asking the government to conduct it at all costs. If required, as they said, they had already given orders to the government of India to send additional paramilitary forces. Now here, the people's representative, the legislators and the legislature took everything into account. And after studying it, they have concluded that it is not possible. We will be facing another situation like in 2017, where there will be chaos, loss of life, damage to properties, and in the end, nothing is going to happen. Because this is not like other issues. Urban local bodies or anything which means election requires the mass participation of the people, the electorates. Now, when the people are already objecting, agitating, and refuse to take part, even if the government notifies, nobody is going to come forward. And without the participation of the citizens, the electorates, it is not going to be successful again. So the matter was brought to the assembly, the state legislature, and the legislative assembly have repealed it. So now the situation is, in the absence of an act, the very act upon which the government is going to conduct the election goes missing. It is no more there. Then upon what act will the State Election Commission or the government go ahead with the elections? So it is up, it is there, where we are now. And coming back to the court's order here, I cannot say that it is a contempt of court when they have not put that word in writing.